starting a business, one of the first decisions is choosing the right structure. Incorporating a business isn't always required, but it offers distinct advantages. Some entrepreneurs may trade in their own name, while others might consider forming a company, close corporation, partnership, or business trust. The choice depends on factors like the number of people involved, capital needs, and strategic goals. Incorporation can provide benefits such as limited liability, perpetual succession, and easier transfer of ownership. Tax implications also play a role, as different entities are taxed differently under South African law. Ultimately, understanding why and when to incorporate helps set the foundation for a successful business journey. Let's compare the main business entities: companies, close corporations, partnerships, and business trusts. Each has unique legal and operational features. Companies and close corporations are juristic persons, meaning they have their own legal identity, separate from owners. Partnerships and trusts, on the other hand, are not separate legal persons, though trusts are regulated by specific statutes. Control differs too. Directors manage companies, members control close corporations, partners manage partnerships, and trustees oversee trusts. Perpetual succession is available in companies and close corporations, but not in partnerships. The number of participants, liability for debts, and record-keeping requirements also vary, making it crucial to choose the right fit for your business goals. Key feature of a company is its legal personality. This means the company exists as a separate legal entity, distinct from its shareholders and directors. The company can own property, enter contracts, and sue or be sued in its own name. This separation provides practical benefits. Directors act on behalf of the company, while shareholders are generally not liable for company debts. The assets belong to the company, not its shareholders. If a wrong is done to the company, only the company can seek legal redress. This concept is fundamental to understanding how companies operate and why they are often preferred for business ventures. One of the main reasons to incorporate is the limitation of liability. When a company is formed, shareholders are typically not personally responsible for the company's debts. Their risk is limited to the amount they invested. However, there are exceptions. For example, in personal liability companies, directors can be held jointly and severally liable for contractual debts incurred during their time in office. This structure is often used by professionals like attorneys. Understanding the extent and limits of liability is crucial for anyone considering company formation, as it affects personal risk and financial exposure. Companies' assets are owned by the company itself, not by its shareholders. This distinction is vital. Even if a single person owns all the shares, the assets remain the property of the company. Courts have consistently upheld this principle, emphasizing that shareholders have a right to participate in the company but do not own its assets directly. This separation protects both the company and its shareholders, ensuring that personal assets are not at risk for company obligations and vice versa. If a company suffers a loss or is wronged, it is the company, not the individual shareholders, that must seek legal remedy. Shareholders cannot claim personal damages simply because the company's value has decreased. This principle was highlighted in cases where shareholders tried to sue for losses resulting from harm to the company. Courts have made it clear, a shareholder's loss is only a reflection of the company's loss, and only the company can claim compensation. This reinforces the separate legal identity of the company. Incorporation and registration are two distinct steps in forming a company. Incorporation is the act of creating the company, typically by filing a notice of incorporation. Registration is completed by the Companies and Intellectual Property Commission, CIPC, which issues a registration certificate. Only after registration does the company gain full legal personality. During the brief period between incorporation and registration, the company may exist in theory but not have full legal status. This process ensures transparency and accountability in the business environment. Companies often operate through branches or divisions, but these are not separate legal entities. Legally, all branches and divisions are part of the same company, even if they operate under different names or have separate accounts. Courts have confirmed that profits and losses from all divisions are combined for the company as a whole. This means that no matter how many branches exist, there's only one legal entity responsible for all business activities. An incorporation usually protects shareholders and directors from personal liability. Courts can lift the corporate veil in cases of fraud, abuse, or improper conduct. This means the court may disregard the company's separate legal personality and hold individuals personally liable for the company's debts or actions. The Companies Act has made it easier for courts to do this when there is unconscionable abuse of the company's structure. However, this remedy is considered exceptional and is only used in serious cases where justice demands it. Companies Act recognizes two broad types of companies: profit companies and non-profit companies. Profit companies are formed to generate financial gain for shareholders and include public companies, state-owned companies, personal liability companies, and private companies. Non-profit companies, on the other hand, exist to pursue public benefit or social objectives and must use their assets to further these goals. Understanding the different types is essential for choosing the right structure for your business or organization. Public company is a profit company whose shares may be offered to the public and are freely transferable. Public companies can be listed on a stock exchange or remain unlisted. The Memorandum of Incorporation, MOI, determines whether a company is a public company. Public companies are subject to stricter regulatory requirements, including mandatory audits and greater transparency. This structure is ideal for businesses seeking to raise capital from a wide range of investors. State-owned companies, SOCIs, are profit companies owned or controlled by the government. These entities provide goods or services in line with ordinary business principles, but are fully or substantially financed from sources other than tax revenue. Examples include South African Airways, Eskom, and the Public Investment Corporation. SOCIs play a significant role in the economy and are subject to both company law and public sector regulations. Personal liability companies are mainly used by professionals like attorneys and accountants. In these companies, directors are jointly and severally liable with the company for debts incurred during their time in office. This structure combines the benefits of corporate personality with the accountability of personal liability. It's important for directors and shareholders to understand the implications, as personal assets may be at risk if the company cannot meet its obligations. Private companies are profit companies whose shares are not offered to the public and whose transferability is restricted by the MOI. There is no limit on the number of shareholders. The MOI can include preemptive rights or require board approval for share transfers. Private companies are popular for small and medium-sized businesses due to their flexibility and privacy. However, they must ensure compliance with the Companies Act, especially regarding share transfer restrictions. Non-profit companies exist to pursue public benefit or social objectives. Their assets and income must be used to further their stated goals, and no incorporator, member, or director may receive financial gain beyond reasonable compensation for work done. Non-profit companies can have voting and non-voting members, and their MOI outlines their governance. When dissolved, their assets must be distributed to similar non-profit entities. This structure is ideal for charities, cultural organizations, and community groups. Close corporations, CCs, were once a popular business form in South Africa, offering perpetual succession and limited liability. However, new CCs can no longer be formed under the Companies Act, 2008. Existing CCs may continue to operate, but members can choose to convert to a company if desired. The transitional provisions ensure a smooth shift from the old legal regime to the new, while protecting the rights of existing CCs. External companies are foreign companies conducting business or non-profit activities in South Africa. They must register with the Commission within 20 business days of starting operations. External companies must maintain at least one office in South Africa and provide details for service of documents. While they are not subject to all provisions of the Companies Act, they must comply with registration and reporting requirements to ensure accountability and transparency. Domesticated company is a foreign company that transfers its registration to South Africa. This process requires compliance with both the foreign jurisdiction's laws and South African requirements. The company must have most of its assets and shareholders in South Africa, and its directors must be or become South African citizens. Once domesticated, the company is treated as if it were originally incorporated in South Africa, gaining all the rights and obligations under local law. Memorandum of Incorporation, MOI, is the founding document of a company. It sets out the rights, duties, and responsibilities of shareholders, directors, and others. The MOI can be tailored to suit simple or complex company structures, but must always comply with the Companies Act. It determines the company's type, governance, and key rules. The MOI provides flexibility, allowing companies to adapt their internal arrangements to their unique needs while ensuring legal compliance. Unless the MOI states otherwise, the board of directors can make, amend, or repeal rules relating to company governance. These rules must be consistent with both the Companies Act and the MOI. Once published, rules take effect after 20 business days or on a specified date. They are binding until ratified or rejected by shareholders at the next general meeting. This system allows companies to respond quickly to governance needs while maintaining shareholder oversight. Companies' MOI can be amended in several ways: by court order, by the board under specific circumstances, or by special resolution of shareholders. Amendments can include changing the company's name, altering share structures, or updating governance provisions. Some provisions are unalterable, while others can be changed to impose stricter requirements. All amendments must be filed with the Commission and comply with the Companies Act. This flexibility allows companies to evolve as their needs change.